Welcome to the presentation on torts. I'm not entirely sure what the chapter number is that appears in your textbook. An earlier version had it as chapter 5, but I think it's a different number now. But in any event, it's a chapter that talks about torts. And so we're going to spend about 30 minutes during this presentation covering intentional torts. And then in a separate presentation, we'll cover the other categories of torts. So let's begin. What is a tort? A tort is a very difficult word to define in the law. In fact, usually when you talk to attorneys or other legal professionals about the term tort, they tell you what it isn't. They tell you, well, a tort isn't a crime, although the behavior that is a tort can also be a crime. And they'll also say, well, a tort isn't a contract claim. But of course, a breach of certain breaching a contract in certain ways can result in a tort. So it's not a very well-defined concept. It's one of those things, you know it when you see it, but it's hard to put a label associated with it. Here's a definition that has some utility. A tort is a violation of another person's rights or a civil wrongdoing that does not arise out of contract or statute. Many times it's called a civil wrong, but it does not arise out of contract or statute. Not very satisfactory, but it kind of gets us started. A related term is the idea of tortfeasor. A tortfeasor is the person who commits the tort. That's the person who's going to be the defendant in the lawsuit, typically. So you could say the tortfeasor is the defendant. Of course, when the lawsuit is filed, we don't know that the defendant actually committed a tort. That's what the jury will determine. But tortfeasor is the common term for that. We'll talk in this presentation. We'll talk about lots of different types of torts, and each one of the torts has its own element, and all of these elements developed in the common law. For the most part, we won't be looking at statutes. That doesn't mean there's no statutes that relate to the area of torts, but certainly the area of torts, just like the area of contract law we talked about, is overwhelmingly driven by common law, by judge-made decisions. And even when a state legislature might jump in and pass a statute, many times what it's doing is codifying or putting in statutory form a part of the common law that had existed for hundreds of years. Now, you might be thinking when we're talking about common law that because there aren't statutes, it must mean that the law in this area is very stagnant, that we're really relying upon concepts from the 1600s or 1700s. And in some respects, that's true, but it's not largely true. This is an area of the law that has evolved significantly in the last 100 years. Some of the evolution is very, very recent, and some of that evolution is statutory, but a lot of it is judge-made evolution, particularly the area of comparative negligence. We'll talk about that. Really, comparative negligence didn't exist except in kind of a theoretical format into the 1970s, and now it is the law in virtually every U.S. jurisdiction. So it's not stagnant just because it's part of the common law. What is the goal of tort law? Well, when we talk about criminal law, let's say I punch somebody in the nose. I punch Bob in the nose. And Bob goes to the police, files a police report, and the district attorney decides to press criminal charges against me. Well, that district attorney sees Bob as his most important witness, and he's concerned about Bob. But his concern about Bob is not the major focus of his attention. He's more concerned about keeping me off the streets, putting me in a position where I am not going to want to punch another person in the nose. So the district attorney is perhaps more focused not so much on Bob, but upon the next Bob. How can he protect the next Bob from getting punched by Gruber? So yes, Bob's an important fact witness. The DA has some concerns about Bob, but for the most part, Bob is not the main emphasis of the lawsuit. If the lawsuit is successful, if the district attorney is able to persuade the jury that I am in fact guilty of this crime, it's not going to really benefit Bob. If I go to jail, if I have to pay a fine, that's not money that goes into Bob's pocket. That doesn't pay for his medical bills. It doesn't pay for his time off work. So that's not ultimately a very satisfying thing for Bob. Now, that doesn't mean Bob doesn't have a remedy. Bob can, of course, sue me civilly for the punch in the nose. Because in this case, that criminal behavior, the assault that we talked about, is also a tort behavior. So the focus of tort law is on the victim, unlike criminal law. And so the focus is, how are we going to make Bob okay? How are we going to return him to the condition that he was in prior to the time of the nose punch? The goal is to make Bob whole. Now, there are some differences between the states in terms of tort law. You'll find gradients of interpretation, shades of differences between jurisdictions. Sometimes you'll find an idea will develop in one state, and it takes a while to get to other states. An example of that certainly is California. California has been a state that has been very innovative in the way it approaches tort law. And many of those innovations have spread throughout all of the states now, but there are other areas where California remains a little bit of an oddball, not necessarily in a bad way, but just different in its practices. Another area that you'll find differences in the law is when parts of the common law have been made into statutes. And much of this falls into the category of tort reform. We'll talk about that a little bit later on. But the general concept behind tort reform is that it's when the state legislature decides, hey, we don't like what the judges are doing. They've come up with some funky ideas. We don't think that they're good for the economy in our particular jurisdiction. Tort reform has existed for well over 100 years. When tort reform kind of initially began, it was designed to make it easier for plaintiffs to be able to successfully sue. So it was plaintiff-focused. It was pro-plaintiff. The reason for that concern at that time was that the state legislatures felt that the judges were too conservative. They were too much maybe in the pocket, so to speak, of the big business interests. Nowadays, when we talk about tort reform, it's usually the other way around. It's the concern that the legislature has that the juries who are awarding big judgments in some cases are too plaintiff-friendly, and that there needs to be a balance there. And so these tort reforms are likely to be focused on reducing the exposure that companies have and making it more difficult for lawsuits that perhaps the legislature perceives of as frivolous, making it much more difficult for those particular claims to advance through the court system. So, having said there are some differences, and the differences are not always trivial, still at the end of the day, in at least 49 of 50 states, if we exclude Louisiana, there's a lot more similarities than there are differences. And in fact, because these concepts in the common law developed, back during the period where we were part of Merry Old England, you'll even find a lot of similarities between our tort system and what you find in Great Britain, or what you might find in Canada or India or other locations. So let's continue on. We're going to be talking about 3 categories of torts, and we're going to break down within these categories to subcategories. But the one we're going to focus on during this presentation are intentional torts. There's also negligent torts and strict liability torts. Most torts fall into the negligent category. A negligent tort, a classic example, is a car accident case. If you stop at a red light and I rear-end you, I promise you, I did not want to rear-end you. I was not thinking to myself, you know what, my day's going so great, I'd really like to be in a car accident today. The fact remains that I should have been paying better attention, and I'm legally responsible for it, but it's going to be a rare situation in which anybody thinks I did it on purpose. So that's the classic negligent situation. But the category we're going to focus on today is going to be intentional torts. And these are situations where, yep, I really did mean to do the action that is in fact the basis of the tort. We'll talk about what that means. Here, what is an intentional tort? It occurs when the defendant takes an action intending certain consequences will result. Again, when I'm driving that car, I did not intend to hit your bumper. But in this situation, I did intend for certain consequences to result. It is not necessary for intentional tort that I intend the harm that happened, but I have to intend a particular action. Now, sometimes I do intend the harm. If I punch you in the nose, that's an intentional tort. I meant to bloody your nose, and if I'm successful at it, I've committed a tort. Let's go to the types of intentional torts. Well, they can be broken down into three categories: torts against persons, torts against property, and torts against economic interests. So you can see here we're focusing upon who is the victim of the tort, who is likely to be the plaintiff. A person, when we're talking about this, we mean a human being, a living, breathing Homo sapien. We're not talking about legal persons in this category, usually, although there can be times where we're talking about legal persons. In the property category, we may be talking about real property, or it may be personal property. It could even be intellectual property in some cases. By the way, we'll be talking about intellectual property in another chapter, so if that's not a term you're familiar with, you will be familiar before the end of this course. And finally, we'll talk about economic interest, how you can have a tort against an economic interest. Let's move ahead. Let's talk about that first category, torts against persons. I'm going to talk about three categories of torts against people. This is not an exhaustive list. It's kind of introducing us to the topic, but don't think, oh, this is all there is. No. There's many, many more categories than the three that we're talking about. But we'll focus on assault and battery, and then also on defamation. So what is assault? Assault is a civil wrong, and these are the words that we saw before in our definition for tort. So basically what we're saying here is an assault is a type of tort, and now we're going to get more clarity about what type of tort it is. It occurs when one person intentionally, well, that's no surprise, we're looking at intentional torts here. That's our category we see in the title, intentional torts against persons. It's when one person intentionally and voluntarily puts another in fear or apprehension of an immediate offensive physical harm. That's interesting, because my guess is before I read the definition, you had a different understanding about what the word assault means. In everyday conversation, when we use the word assault in English, we mean somebody punched me in the nose. We don't mean somebody scared me by waving their fist around. And yet, in tort law, assault doesn't mean that I actually bloodied your nose. It meant that my fists were balled up and I was menacing towards you. I was moving around and saying things indicating that I was about to hurt you. I may never actually touch you and still be guilty of assault. So it's a different spin on the term assault than we have in everyday conversation. There is a way that I recommend you think about assault to help you remember the distinction between assault and battery. The next slide we'll talk about battery. Assault is usually followed by a battery. So I've balled up my fist. I'm saying, I'm going to punch you in the nose, and I'm getting really close to you, and I'm scowling, and then I punch you. Well, the punch is the battery. The assault is the threat. And so in English, what comes first? A comes before B. Assault comes before battery. Now, it's possible to have a battery with no assault. For example, if I punch somebody who's asleep, even though I was having my fist balled up and I was close to his face, he didn't know I was there. So his first knowledge that there's some reason to be concerned is the pain that he feels when I actually batter him, when I actually commit the violent act upon him. So in that case, there's a battery but no assault. So let's look at the definition here of battery. So we again have the idea of it's a civil wrong. This is the idea of a tort, right? This is no big surprise here. And it occurs one person intentionally, okay, well, we're expecting to see intentional torts here, and voluntarily brings, so this is just a repeat of what we saw with assault, a non-consented, harmful, or offensive contact with a person, or something closely associated with the person. So you can actually do a battery, say, by me grabbing your purse or grabbing your briefcase or something, or your coat or something along those lines. So I don't even really have to touch you, even in the case of a battery, although certainly that's a classic example. It's also not necessary, I should have a T here, so use your imagination here, there's a T. It also isn't necessary that the person actually be injured or be harmed in a physical way. So for example, if I'm groping somebody in the stairwell, under those circumstances, I might not harm them at all, but I have committed a battery because it is offensive to that person, assuming it is offensive. So we need to have actual contact with battery. We don't have to have that for assault. Let's look at some defenses to battery. We have consent. So as you saw before, we needed no consent. It was part of the definition. So if the person wanted me to punch them in the nose or they wanted me to grope them in the staircase, then there is consent and therefore there is no battery. Another defense is self-defense. So if somebody is about to punch me in the nose, I can punch them in the nose. Or at least I can have the argument that I was doing it to protect myself from that injury. Usually you're allowed to protect yourself if you have a reasonable fear that you're going to be significantly injured and you can't escape from the situation. Just like you can have the defense of self-defense, you can also have in defense of others. If I see somebody about to pummel another person and I intercede and punch the aggressor, I would be defending the other person. And I can defend somebody even if they're not a member of my family, even if they're not a child or an elderly person. They may be a complete stranger to me. I don't necessarily have to have a relationship with that other person. And it probably makes a stronger case if I have that relationship because, of course, if I don't know the person, maybe I don't know the dynamics of what exactly is going on in the relationship. You can even have a defense in a battery case when it's a defense of property. So if I see somebody with a lit torch, and it's pretty obvious from what they're doing that they're about to burn a building, I can restrain them, which of course would be an offensive touching, so that they don't actually take that torch and light the building. So defense of property can arise. Now, obviously, there's a limit to what you can do for defense of property. The response to the defense of property has to be reasonable under the circumstances. You've probably heard of the Trayvon Martin / George Zimmerman case. That's the Florida case. Sometimes it's called the Stand Your Ground case. Mr. Martin was a young African-American man who died as a result of a situation that arose between he and Mr. Zimmerman. Mr. Zimmerman was an adult man and was active in the Neighborhood Watch program there. And Mr. Zimmerman was tried for second-degree murder because it was the prosecutors believed that his claim that he was acting in self-defense, that there really wasn't a true defense situation there. The jury didn't agree with the district attorney. Actually, it wasn't district attorney, it was a special prosecutor in that case. But in any event, that was a criminal case. The case could also have been advanced by Mr. Martin's family. It may well be advanced by Mr. Martin's family as a tort claim, that in fact Mr. Zimmerman committed a tort of battery against Mr. Martin, and under those circumstances, I think everyone would agree that Mr. Martin did not want to be harmed or killed, and so Mr. Zimmerman or Mr. Martin's family would be able to fairly easily make the battery argument, but Mr. Zimmerman would come back and say, well, yes, but I was engaging in self-defense. So it's a similar structure that you would have in a battery situation, whether it's a criminal matter or a civil matter. In Texas, we have a defense that is somewhat similar to the Florida Stand Your Ground defense. There's some different aspects to it, though. Traditionally, in the common law, if I'm in my home and I believe that somebody is trying to break in and I am fearful that they're going to harm me, but I feel like I can safely escape maybe through the back door, I am legally required to flee in order to avoid having that interaction. I can't stick around in the common law and shoot the person and claim self-defense if I could have fled. And the logic behind it is, well, even though this is a bad criminal, even bad people, we don't want to have kind of a vigilante style of justice. So if there's a way to avoid killing somebody, we ought to require that the homeowner or the resident flee if it can be safely done. Well, Texas and many states, including a fair number of western and southern states, have taken a different stand on that issue. They have rejected the common law standard and have developed what is oftentimes called the castle defense, which is, again, similar to that stand your ground idea. And the idea is, every man's house or every woman's house is her castle. And so we ought not have to flee from our castle. We ought to be able to stand and defend it. And so under those circumstances, someone's breaking into our house, even if I can safely flee, I don't have to. I can stand my ground and I can engage in self-defense under those circumstances. In Texas, the castle defense applies to my home, where I live. It doesn't have to be the home I own. It could be an apartment or someplace I rent, and also to my vehicles. So in this situation, I don't have to flee. But just be aware that if you're not in Texas when the situation arises, the castle defense may not be available to you. So keep that in mind as you move around the country or visiting other parts of the country. So we've talked about assault, we've talked about battery. Let's also talk about defamation. Defamation is another type of intentional tort against a person. What is defamation? Well, of course, it is a tort, and it's an intentional tort. It is a false statement or an action that harms the reputation or character of an individual. And again, this isn't restricted to human beings. It can be a business or some other group or category of folks. So let's talk about what defamation is not. It isn't an opinion. If I were to say, oh, you don't look good in yellow, that is my subjective opinion. It can't be proven true or false. After all, I think you look a little jaundiced when you wear yellow, but somebody else might think it's the best color for you. There's not a right or wrong answer for that. Now, that is not 100%, when I say an opinion means that it can't be defamation. That's generally true, but there are some times that it's not true. For example, if I were to say this, it's my opinion that you murdered your mother. Well, really what I'm saying by adding the words, it's my opinion, isn't going to change the fact that I am in fact accusing you of murdering your mother. If it is a false statement that harms your reputation, then that could well be defamation. So just saying it's my opinion doesn't change a defamatory statement into not a defamatory statement. Of course, in order to be defamed, the person has to have a reputation that is being damaged. So if I were to make a false statement, something like this, let's see, what's an example? Let's say I'm looking at somebody who has brown hair, and I were to say, your hair is red. Well, it's a false statement. His hair is brown. But having red hair is not damaging to a person's reputation. So it's a false statement, but it wouldn't qualify as defamation. Defamation is broken up into two subcategories. One is libel, and the other is slander. Libel is something that is in a permanent format. Typically, it's going to be published or written down in some way, but it can also be something that is recorded or something that is in a film or some kind of video clip. The way to remember that libel is in the written form is you can think of as libel is letter, or also libel is lasting letter. It's a permanent format, and therefore it's a more serious matter than its kind of partner, which is slander. And slander is spoken defamation. So slander obviously starts with an S, and spoken starts with an S. So that's the way to remember it. Libel is lasting letter, and slander is spoken. Hopefully that will assist you in keeping those two straight. They're both types of defamation, so therefore they're both intentional torts against persons, but they're subcategories of that larger category. So let's look at some defenses to defamation, be it libel or be it slander. One is, it's the truth. If what you're saying is true, if I really did murder my mother, guess what? I can't successfully sue you for defamation. Truth is an absolute defense. I can't be liable no matter how damaging that information is, because guess what? You deserve to have your reputation damaged if you did what I said you did. Another situation in which defense arises is privilege. And this is an affirmative defense. An affirmative defense occurs when the defendant says, yep, I did it, sure did. But guess what? There's a reason why I'm not responsible for it. And there's two ways that you can have a privilege. One is it can be an absolute privilege, meaning, yep, it's a free get-out-of-jail card, so to speak. Another is when it's a conditional matter. So let's look at when an absolute privilege exists. When you have an absolute privilege, it's impossible for me to successfully sue you for defamation, no matter why I made the false statement, no matter whether I knew it was a false statement or not. There are very few times that an absolute privilege exists. I guess maybe the classic example is if I'm a senator or a congressman or woman and I'm on the floor of the Congress, I can say whatever I want, and I cannot be sued for it. I may know that it's a bunch of hooey, that I've lied and distorted the truth, and that I've harmed someone's reputation. I may know that C-SPAN is recording everything that I'm saying, and this is going to be front page news in the newspapers tomorrow. But guess what? I still can't be sued. Another place that you can't be sued for defamation is when you are under oath in judicial proceedings. Now, of course, if I lie, I can be prosecuted for perjury, but I cannot be sued for my testimony in court. Let's look at what a conditional privilege is. This is a situation in which I can't be sued unless I had actual malice when I made the false statement. I had to know it was false, or I had to be very, very careless about it. I had really good reason to think it was false, and I continued to say it despite that fact. One example of a conditional privilege has to do with job recommendations. If you've done much work with larger employers especially, you've probably encountered the fact that employers don't want to give references. They don't want to give good references, but they especially don't want to give bad references because there's really no upside. Let's say you worked for this employer for a while and you've left and you're trying to find another job, and you might call up your former boss and say, "Hey, boss, I did a good job for you. Sure would be helpful if you would be willing to write me a letter or be my good reference when I get another nibble. I'd like to be able to refer them to you." And very likely your former employer says, "Nope, can't do it. It's against company policy." The employer is going to say that for a few reasons. First of all, how is it helping the employer to give you a good reference? You no longer work for that employer. So the employer doesn't really see a benefit for it in giving you that assistance. But there's probably a more central reason, and that is, what if it gives you a reference and maybe it says something generally positive about you. Let's say it says something like, Bob is a real go-getter. He's real aggressive and real tenacious and has a good work ethic. And so this information is shared with that potential employer, and the potential employer is thinking, sounds like Bob is real jerk. I don't really want to have somebody that aggressive or that tenacious in the work environment. I like a more calm, sedate type of worker. So even though maybe the company that gave the reference was thinking it was giving a good reference, in fact, it really wasn't giving a good reference for that particular place of employment. Another reason an employer doesn't like to give a reference can be that, especially if it's a telephone conversation, that they can't always anticipate what the question is going to be. They may be persuaded, I'm only going to give a positive reference. I'm only going to say wonderful things about Sue. But when they actually get the call, the first question out of the person calling them is, well, tell me about Sue's attendance. And the truth is, Sue would be late pretty regularly. Sue was a wonderful worker, and it really didn't bother you a bit that she was late. It wasn't the type of job that it really mattered whether Sue got there exactly at 8 or whether it was 8:05. But you're being asked a direct question, was Sue on time? And, you don't want to lie, so you say, gee, Sue was awesome, but no, she didn't come to work on time. Okay, that's all I needed to know. And now Sue hasn't gotten the job, so what you thought was going to be a great reference ended up not being a good reference. But even when you really, really do give an honestly good, awesome reference, it can still backfire against you. Imagine that Larry is my employee or my former employee. And I like Larry, but I know Larry is bad news. Part of the reason maybe I'm giving him a reference is to get rid of him. Maybe I'm worried he's going to reapply for his job, or maybe he's still employed with me, and I want him to move on. So I say all kinds of, Larry's awesome. You want to hire Larry for sure. But I'm really thinking to myself, boy, I hope you hire him so I don't have to deal with him anymore. So the other employer hires Larry, and Larry ends up being, an axe murderer, and he mows down 20, 30 people in the work environment. Well, some of those victims talk to Larry's employer at the time and say, why'd you hire Larry? Everybody knows Larry's an axe murderer, And the employer goes, well, I checked references. And, it was his other employer. It was that Groover chick. She's the one who said Larry was awesome. And so now suddenly I, Groover, am being sued because I said good things about Larry, when things that I knew that weren't true. So those are the reasons why, as a business person, you are probably not going to be giving, certainly not negative references and probably not positive references. Having said all of that, like many states, the state of Texas does provide a qualified privilege for job references, and here is the statute. An employer is immune, meaning not legally responsible, for giving a bad reference unless it is proven by clear and convincing evidence. So this is, of course, what the plaintiff has to prove, and this is the standard, clear and convincing. We'll talk about this standard in just a second. That the information disclosed was known by the employer. So there's no reckless standard here. You had to assertively known that to be false at the time of the disclosure, or the disclosure is made with malice or with reckless disregard of the truth or falsity of the information disclosed. So if I've just been a little careless, maybe I said Sue had been tardy 7 times, and really she'd only been tardy 6 times. But, it wasn't a complete fabrication. I was in the ballpark. Sue can't successfully sue me. Now, if I happen to know Sue had good attendance and I start making up stories about, oh, yeah, she'd always be late, well, then this code isn't going to protect me because I knew that what I was saying was false, and because it was false, it damaged Sue's reputation. It prohibited her from getting that job. Now, let's talk for a second about clear and convincing evidence. There are 3 main standards of evidence that we have in our legal system. The first is what we call preponderance of the evidence. This is that, I'll call it POE, preponderance of evidence. This is that 51% standard. The plaintiff has to persuade the jury that it's 51% likely that the plaintiff's version is true. It's a really mild standard. It's not at all hard for the plaintiff to make that. But there's a slightly higher burden on the plaintiff than there's on the defendant. Of course, in a criminal case, the prosecution has to prove beyond a reasonable doubt. There's no percentage associated with this, but you can think of it as being maybe 99%, maybe 95%, but very high standard of proof. So you can see how in a civil case, you might be able to persuade a jury that the preponderance of evidence standard means the plaintiff wins. But with the same facts, the defendant gets off in a criminal case because the level of proof is somewhere in between these. This would be an example of O.J. Simpson. O.J. Simpson was acquitted of killing his former wife, but he was held civilly responsible for her death. So again, the evidence must have been somewhere between 51% and 99% to support that type of claim. So we aren't talking, though, about either one of these standards when we talk about clear and convincing evidence. Clear and convincing evidence is in between clear and convincing evidence. This is also a civil standard. This is not as common as preponderance of the evidence, but it's a higher standard. And when the courts or the legislature said that plaintiffs have to prove this level, what the plaintiff has to do is show to the jury an amount of evidence so that the jury has a settled feeling that this is how things happened. When you're at preponderance of the evidence, when it's 51-49, the jury still really doesn't have a good feel. They're still thinking, it really could be either way. But clear and convincing evidence means that they're not certain. They're not even to beyond a reasonable doubt, but they're maybe 70 or 80% confident. That would be clear and convincing evidence. So that's what we're talking about. So it's a higher level of proof. So there's really 2 things that you get with this code. You require a higher level of proof, and you require that there be a fair amount of misconduct on the part of the employer before there's going to be liability. But it's just a conditional privilege. It can be overcome. Another conditional privilege is the public figure privilege. And let's go on. We're going to go forward to, we've talked about the torts against persons. Now we're going to talk about torts against property. And here are, again, 4 examples. This is not an exhaustive list. I'm going to go through these pretty quickly. So what is trespass to realty? This is also then called trespass to real property. And this is what we think of as trespass. This is when I go on your land without permission, or I take your property without permission. I'm sorry, no, forget that. That was wrong. I misstated that. Take back that last part. I place something on your property without permission. If I take personal property, it's not trespass to realty, so disregard what I just said, that part of it. You can also have something called a private nuisance. This is when somebody uses her property in an unreasonable manner that harms the neighbor's use or enjoyment of the property. So let's say I put a big stinky factory next to your house, and it's belching out smoke 24/7. It's a terrible smell. It's an eyesore. Under those circumstances, even though I'm not doing anything on your land, I'm certainly creating a private nuisance. Let's say I dam up the local creek so that your land floods, or perhaps I am throwing a party every night, and so the noise makes it impossible for you to sleep. Those are examples of private nuisances. Technically, I haven't trespassed to your realty because I haven't put my big toe onto your land, but my nuisance has. My nuisance has snuck across the border and has been a problem for you. So we were talking about trespass to realty. Now we're going to talk about the other kind of one that I was almost talking about before. And that's trespass to personal property. This is when I take your purse, or I, example, borrow your bike without permission, or somehow or another I create a circumstance in which you are not able to use the item that you were using. That's an example of trespass to personal property. Keep in mind, this doesn't have to be intentional. Maybe it's a rainy day and I grab your umbrella thinking it's my umbrella. I didn't mean to steal it, but that would be an example of trespass to personal property. Conversion is a kind of trespass to personal property on steroids. This is the more extreme case of this particular tort. This happens when there's a permanent interference. This was temporary. Now we have permanent. So conversion is permanent. Trespass to personal property is temporary. I've taken it. It's not yours. I mean, it's still yours legally, but you aren't getting to enjoy it. And so this would be not borrowing the bike for a joyride. It's stealing the bike. And, of course, this even falls in the category of, I think it's my umbrella. I never really bothered to look at it that closely, and I've kept it. But I think it's mine. Still, though, I'm guilty of conversion. There's not really a kind of a mens rea like in a criminal situation associated with that. So we've talked about two categories of intentional torts against persons: assault, battery, defamation. We've talked about torts against property. We've talked about conversion. Trespass to personal property. We've talked about private nuisance. We've talked about trespass to realty or real property. And now we're up to torts against economic interests, which I guess the first few examples we've done so far, I guess, let me flip back here for a second. From a business standpoint, private nuisance can be an issue, but for the most part, these haven't been focused that much on business issues. I mean, you can have a business tort in these situations. So here are the intentional torts that have to do with economic interest. So these are more likely to have that business law connection. And let's go through them quickly. Okay, so we're going to look at 5. Of course, this is not an exhaustive list. This is just kind of a sampling of some of the big ones. And some of the names of these torts are going to be a little bit different from one jurisdiction to another. The concept of the tort will be there, but they might prefer a bit different terminology. So let's look at these. And again, these are commonly called business torts because, as I say, they have to do with business-type interests. There's disparagement. This is similar to defamation, but it's about a business's reputation, not a human being's reputation. Now, defamation can be against a business, but more commonly you're going to see the term disparagement. But it's the same concept. So think disparagement, defamation. You've got your D's going here. D for disparagement, D for defamation. Now let's talk about intentional interference with contract. Many times in Texas and other locations, this is called intentional interference with business relations. First word we're seeing here, again, we're seeing the word intentional. You may be wondering, why don't we have intentional disparagement or intentional defamation? Um, and let me flip back here for a second and talk about this one. When we were talking about this, I said before that conversion, it can be by accident. So how was that an intentional tort? Well, I intended to grab the umbrella. I thought it was mine. I didn't think I was committing a tort when I did it. But I did really mean to grab the umbrella that I, in fact, grabbed, even though I was under the mistaken belief that it was, in fact, my umbrella. I am still guilty of the intentional tort. I don't have to intend the harm. I just have to intend the action. So a little clarification there. But here we have intentional interference business relations, or contract in this case. And the reason we need the word intentional is because you can have negligent interference with contract. That's not a tort that's recognized in Texas or that many jurisdictions. But they put the word intentional here to say, hey, we're talking about something different than that negligent interference in business relations. We're talking about intentional. And the intentional tort of interference with business relations or contract is recognized, I assume, in all jurisdictions or virtually all jurisdictions. So what does the plaintiff have to prove? Well, first of all, the plaintiff has to prove that there was, in fact, some kind of contract or some kind of business relationship. Obviously, you can't interfere with something that doesn't exist, right? So you've got to prove that there was this contract. It existed. You have to show that the defendant, a little d here, I was not successful with that, put a little d here. The defendant, so we have party 1, and party 2. And they are in privity. They're in contract. And then we have defendant here, which is party 3, and he's doing something to get in between the two parties, or at least that's what the allegation of the plaintiff is. But if the defendant, the plaintiff here, had no idea there was this contract, I'll show the contract by a little arrow going back and forth, didn't know there was a relationship, and he sticks his nose in, he can't really be blamed for that. And so he has to know there has to be a contract between party 1 and party 2, and this third party has to know about the contract. And after knowing about the contract, the defendant has to intentionally try to persuade one of these guys to breach it. So he whispers in number 2's ear, hey, you don't want to follow that contract. You want to breach it. It's going to be awesome. It's going to work out so well for us. And then, of course, we'll assume that party number 1 is the plaintiff. Party number 1 suffered an injury. Actually, party number 2 actually did follow party number 3's advice and did breach, and that caused party number 1 harm. Now, of course, party number 1 can, in fact, sue party number 2, but it may be that party number 2 is in a deep pocket. There's no point in suing somebody who doesn't have money, but party the third part may have significant resources. So, an example of this is when an employer lures another employee away from another employer. So, party number 1 is the employer, party number 2 is the employee, party number 3 is the other potential employer who says, hey, number 2, come work for me. Now, that usually will not rise an intentional interference with contract claim if this other company just wants to hire party number 2. It's only when the new employer is taking away this second party, not because he wants the second party services, but because he wants to sink the competitor's business. That's when it becomes intentional interference with contract. This comes up very often in the high-tech industry. In the telecom corridor here is one area that we see this come up in. And it may be an employer that takes a whole department, hires everybody in that department. Maybe not so much because they really, really want those people, but because they know if we hire these people away, that competitor is not going to be able to meet their schedule for deliverables in a certain product line or something along those lines. Let's talk about unfair competition. Of course, competition is an essential part of our economic system. Competition is a good thing. But there can be a tort of unfair competition. And this is when you're competing not to make a profit, but just to drive the other person out of business. Let's say that we're a very wealthy company. We've got a lot of cash. We're able to enter a market and actually sell our items at a loss. And because we have this buildup of cash, much more money than our competitors do, we keep on selling our product at a loss, and we eventually drive our competitors out of the market. Once we don't have any competitors, then of course we jack up our prices because we have a monopoly. That would be an example of unfair competition. It's hard to prove that type of situation, and of course there are statutes about, in the antitrust implications of some of those ideas. But there's also this tort claim of unfair competition. Now let's talk about misappropriation. Again, this is an intentional, illegal use of property or funds of another person for your own use. And this is usually arises when somebody has a fiduciary duty. A fiduciary duty is a responsibility to protect another person's assets. A person has a fiduciary duty would be one's attorney, one's banker, something along those lines. Somebody who has a position of trust that the other person reasonably says, hey, that person's on my side. So let's say I'm your attorney, and say I'm Bob's attorney, and Bob comes in and goes, Groover, I'm going on a trip. There's going to be some bills coming due. I'd sure like for you to just take care of them. So I'm going to make you a co-signer to my personal checking account. And by the way, I have $50,000 in it. And so he goes out of town, and he tells me which bills I'm supposed to pay, and the total amount of bills is $5,000. But you know what? I've had some reversals in my business, and so I start quote-unquote, loaning myself some money from it. Maybe I intend to pay it back, or maybe I do, maybe I don't, but still I have misappropriated those funds. I've also probably embezzled the funds. But from a tort perspective, we might be talking about misappropriation. And then there can also be a fraudulent misrepresentation. And this is when I'm using intentional deceit to facilitate a personal gain. This might sound a little bit like defamation, but you see that doesn't have to harm a person's reputation. So I might say something like, actually it can arise, I can make a fraudulent misrepresentation that's also defamation. I could say, oh, don't buy my competitors' hamburgers. They use ground glass in the hamburger meat. And, this will make you very, very ill if you do that. Buy my hamburgers and you won't get ill. Well, I've defamed my competitor. I've disparaged my competitor, but I've also fraudulently misrepresented it for that personal gain. Usually in the case of defamation, there isn't the need or many times even the facts to support the possibility that the defamer is actually going to receive additional money as a result. But with a fraudulent misrepresentation, there has to at least be the goal of gaining something. So we have now completed the types of intentional torts. We talked about intentional torts against persons, intentional torts against property, and intentional torts against economic interests. So we have covered the intentional tort section. Our next presentation will be on negligent tort and strict liability torts. Thank you for your attention. If you have any questions, please bring them to class, and we'll be happy to talk about those at that time. Thank you very much. Bye-bye.